Section 3 in particular, as opposed to applying Section 3 of the 14th Amendment through other more general federal statutes.
Adam, the only thing I would mention here is that it should not be lost on anyone that the text of Section 3 does not say any of this, and that the majority opinion is reading words into this provision that clearly are not there. And as we made clear in our briefing, and as numerous amicus briefs from historians and legal scholars made clear, Section 3 of the 14th Amendment is self-executing, and Donald Trump is disqualified as of this moment. But obviously, the majority opinion takes a different tact, at least in terms of enforcement.
All right, now we're going to hear from Daniel Lathrop at Scripps News. Daniel, if you wanted to ask your question.
Yeah, can y'all comment on the substance of Justice Coney Barrett's concurrence, in particular her assertion that the majority was unnecessarily raising the temperature of our political debate?
Eric, I don't know if you wanted to.
Sure, happy to do it. I guess I'd make two comments on Justice Barrett's very brief concurrence. The first is that I think she's showing to be more concerned about what voting rights folks call the democracy docket, sort of how the court works with election-related issues in a way that's a little more voter friendly, if you will, than some of the more conservative members on the court. So that's welcome news. And the second is, I think it's an effort to get the headline, which say, hey, don't forget we got 9 justices here that all agree on the outcome, to try to paper over some of the real deep division on the court, the 5-4 division on the court about what this means going forward and in future cases that we've been talking about. So I think it's welcome news. I wish she would have said more, but I appreciate she said something, even though I think the effort to put the headline at the end of the concurrence is ineffective. It buries the lead, if you will.
Great. And now we'll hear from Isabella Murray at ABC News. Isabella?
Hey there. Yeah, I was just wondering, you'd mentioned it a couple times, but this issue really being in Congress's hands now. I'm wondering if you all have been in contact with any Congress members, or if this is sort of the end of the road for you, what your kind of partnership looks like there, and what actions there might be to move this forward.
I'm happy to jump in. I guess I would start by saying, this is not remotely the end of the road for us. I think we believe today, as we did yesterday, that Donald Trump poses an imminent threat, a clear and present danger to our democracy, that the framers of the 14th Amendment had it right when they concluded that those who attacked the Republic, who attacked the democratic form of government that we all hold dear, are a danger to do so again. I think Donald Trump's doubling down on his defense of January 6th and his anti-democratic intentions should he be reelected confirm the wisdom of the framers of the 14th Amendment. So we're not going anywhere. We care deeply about this. We think the law and the Constitution are clear that that Donald Trump is prohibited from office, even if an enforcement mechanism has been taken off the table. I think as far as what the steps are going forward, we're just reading this along with you all, and I think we are figuring out whether there are steps in connection with this provision. And we certainly have worked closely with members of Congress. Actually, 2 members of Congress testified at the evidentiary hearing that was held in Colorado. There are other members of Congress who have who have spoken out about the 14th Amendment disqualification clause. So we certainly expect there will be interest in Congress as to whether there is a practical path forward for congressional action. I think it's early to say that, and I think we'll be looking into that, and we'll be looking into what other avenues there might be, whether it's rooted in the 14th Amendment or otherwise, to try to protect democracy from those who have attacked it.
And I would add to what Noah said that, that there's issues for Congress, and then there's also issues for the American public. And I think that the court's opinion also tees up the question, to the American public of, you also get to decide whether you think that this person is eligible to hold the office. And in the same way that most people wouldn't think to vote for Barack Obama or George W. Bush for a third term because the Constitution says you can only hold 2 terms. Or in the same way that most people wouldn't vote for someone who was born abroad or who's too young to constitutionally be eligible to be the president. We think it's a compelling argument that people should really consider whether they want to vote for president for somebody who has been adjudicated in a trial in Colorado to be an insurrectionist and therefore to be ineligible to hold the office.
All right, and now we're gonna hear from Zach Montalaro at Politico. Zach, you there?
Hey, y'all. Thanks for doing this. I think I typed my question in earlier, and I think you mostly addressed it, but I'll just re-up it. What is Cruz's level of concern, I guess, on like a post-election attempt to disqualify a president-elect Trump if he wins? If he does indeed win the election in 8 months or whatever, would a post-election attempt to disqualify him under the insurrection clause and not to count as electoral votes be the right path to take if the American public does vote him in?
I guess I'm happy to jump in. I think it is. I think it's premature to, at least for me, to weigh in on that. I think that we do continue to believe that Donald Trump is, as Donald Sherman said earlier, is as of now constitutionally disqualified because he did engage in insurrection after swearing an oath to support the Constitution, and we don't see anything in today's opinion that changes that. As Jason said earlier, along with Congress, the American people have a role in determining, what they're going to do with findings that support the conclusion that this is a candidate who is constitutionally ineligible. Obviously, congressional action on January 6th would be an unprecedented step, and in terms of thinking through both whether the Supreme Court left that option open and also whether that option is the best thing for democracy, I think we have some reading and some thinking to do on that. But we do think that going forward, not only is there still an open case, but we think that there is a clear case that Donald Trump remains prohibited from office under the 14th Amendment, and that'll be something for Congress and for the American people to grapple with in the months going forward.
So obviously we all thought we should win, but your question is emblematic of why the off-ramps that the court took and the off-ramp that the court took in this particular instance doesn't answer all of the questions. This is the part of the conversation where I note that a bipartisan majority in the House and then 57 senators, and you can't get 57 senators to vote for anything, have already voted that Donald Trump incited an insurrection. And so, I think there's a question for Congress. And I think the threshold question is, we believe that the disqualification already exists. I think the question for Congress is potentially, does it exist now? Do they need to remove the disqualification by a 2/3 majority? But again, the reason why these questions remain is because the court took an off-ramp where we believe that it shouldn't have, that is not supported by the text and not supported by the law. But we are we have always said that we would abide by the court's decision. We hope that Congress follows the law, and the court has left some of these questions for them to work out.
Great. All right, and now we hear from Sam Levine at The Guardian. Sam, if you want to ask your question.
Hi, thank you guys for doing the call. I just wanted to follow up on a couple of the questions that have been asked. I mean, just more specifically, do you guys think today's decision, precludes any effort after the election for Congress to try and not count votes for Trump if he wins the election? Because the majority opinion seems to have some thoughts on that, saying that they would be very skeptical of any effort short of passing legislation. I think the language they use is up to and even perhaps after the inauguration. So, in your view, does today's decision leave open that possibility of trying to block, of Congress, using its power to try and block certification of the Trump win?
Jason, I don't know if you wanted to start that.
Yeah, I think that gets to issues that we've already touched on before that we need to look at a little bit more closely. But certainly, the three concurring justices seemed to read the majority opinion that way. They seemed to say that you would need an actual act of Congress providing a specific mechanism for enforcing Section 3, and not just trying to enforce that constitutional provision through general laws like the Electoral Count Reform Act. It's really not clear where the majority is getting that notion. Certainly, there's nothing in the text or history of the 14th Amendment that would support that conclusion. But it does seem to be at least implicit in the ruling today that trying to enforce Section 3 through other means other than specifically enumerated legislation would raise serious questions, legal questions under the decision today. But we're continuing to look at that.
Great. All right, and we are going to hear now from William Hibbets at Jurist. William, can you ask your question?
Hi, yes. At the beginning of the conference here, you highlighted the fact that the court left in place the Colorado Supreme Court's finding that Trump did engage in insurrection. And subsequently, we've discussed how there was division on the court relating to the mechanism that Congress is to use to enforce this legislation. I was wondering, do you believe that the Supreme Court, the U.S. Supreme Court, was unwilling to touch on the Colorado court's factual findings because of underlying division or concern about political ramifications?
I don't want to speculate too much on the sort of motivations of the justices. I think what we, as sort of the legal team in this case, feel very strongly about is that the law and the facts were undeniable on Donald Trump's engagement in insurrection. There was, from the U.S. Supreme Court to the dissenters on the Colorado Supreme Court, to the trial courts that have looked at this, we haven't really seen anybody who has really attempted to take issue with the legal conclusion, the factual and legal conclusion that January 6, 2021 was an insurrection and Donald Trump engaged in insurrection. So clearly what you had today was a Supreme Court that was not comfortable getting to a place of removing Donald Trump from the ballot under this provision. But I think recognized that there was no credible way to open up the issue of Donald Trump's engagement in insurrection and to even try to make a case that conclusion wasn't supported. As a matter of law, the decision below was reversed, so it doesn't stand up. But those conclusions about Donald Trump's engagement in insurrection, they didn't even try to lay a finger on that, because I think ultimately they really couldn't. There just was no basis that with a straight face they could pursue to really even any of the justices seemed to believe that they could pursue to take issue with that conclusion. So I don't know exactly what their motivations were, but I would come back to the fact that just the facts in the law weren't there to open those issues up.
And one more question from Daniel at Scripps. Would the Supreme Court decision allow the DC Code writ of quo warranto statute to be enforced? Donald?
So, Adam, let me go back to the first question. Just to say, we saw a couple of concurrences in this case. There was no concurrence also supporting the idea that Donald Trump was not an insurrectionist or that January 6th wasn't an insurrection. And so I think that's noteworthy as well. With respect to the DC quo warranto statute, that is a great question. I have not an answer for you at this moment, but that is certainly something that as we read the decision and then read the statute, which we've read before, but not obviously in this context, that we may have some thought on, but whether we would share that with this group, probably not.
Great. All right. And I think that we are going to end here. Noah, Donald, Jason, I don't know if you have any final thoughts to say before we close out the call. Noah?
I'd say only this, just that I think in some ways the sort of easy story to tell today is Donald Trump won. Donald Trump's on the ballot. And certainly, as one of the questioners pointed out, that is, as a matter of winning and losing, that is true. But I don't believe that actually tells the story of what this decision from this Supreme Court is actually saying and is actually doing. That when you see a court sort of trying so hard to find a narrow technical off-ramp, and not even addressing for a moment the ultimate findings that Donald Trump was an oath-breaking insurrectionist. That has to be a major part of how we look at this. And with that, I would just say thank you all for joining us, for your attention to this incredibly important case for not just for sort of jurisprudence, but for democracy.
Thank you. And if all of you, we have recorded this, so if you like the recording, please reach out to our press team. We can send that to you. And as always, send us any other questions that you have. Thank you so much.